Ladies and gentlemen, this is the court of public opinion. We are in the judicial harlotry series of videos. This particular video, I title it A Poop Marked Court. The application to find Mr. Ojal, the CEO of Mwalimu Sacco, and Mwalimu to be in contempt of the tribunal, and the case challenging my suspension and denial of a loan by Mwalimu were listed on the same date at Mombasa. As we approach the cooperative tribunal, where do we stand? The issues in the cooperative tribunal case number 1 of 2007 at Mombasa had been before the tribunal since 2004. That case that was before the tribunal in 2004 was a class action suit because we thought there were common streaks between the three complainants in this case. The tribunal, in its wisdom, ruled after consideration that the three complainants before the tribunal file separate cases. That is what resulted into the cooperative tribunal case number 01 of 2007. Mwalimu National filed their defense through the law firm of Mose and Mose Advocates. Mwalimu National's defense of the case was basically in three parts. One was geographical jurisdiction, their argument being that the event in question happened in Nairobi and cannot therefore be prosecuted in Mombasa. The other one was legal jurisdiction, that the issue at hand was not an issue for the cooperative tribunal, but was an issue for the courts, as they put it. Their third ground for challenge was on res judicata. That means that the issues at hand had already been decided earlier. Those were all very tired kind of defenses. So I won the case. As I approach the Honorable Asenath Ogeri Tribunal, I have already won the case before the tribunal, before that one. I have a decree of the tribunal and I have warrants of attachment against Mwalimu. The first warrant of attachment was in the name of Fantasy Auctioneers. Now, Fantasy Auctioneers, with a duly filled warrant of attachment, has gone to the premises of Mwalimu Sacco and opened the case. They had the warrant, but they decided to accept arguments from Mwalimu Sacco about monies that had been paid. That was very unprofessional on the part of Mr. George Gitonga Muchiri. As an auctioneer, your business is not to go and conduct proceedings in the premises of the person against whom you have the warrant of attachment. As I said in the reply to his very sick letter, it was not his business to open and conduct new proceedings in the premises of Mwalimu Sacco. His business was to recover the money as decreed by the tribunal. In the contempt case against Mr. Ojal, the then CEO of Mwalimu Sacco, and Mwalimu Sacco itself, Mr. Ojal and Mwalimu Sacco are being represented by Mr. Mudhama. Now, Mr. Mudhama, by his own testimony, is an employee of Mwalimu Sacco. He was then the credit manager and very proud of his then recent qualifications as an undergraduate. In the case challenging my suspension and denial of a loan, Mwalimu Sacco is being represented by Mr. Kinyajui of the law firm of Mazayo, Mrima and Jadi. The representation of Mr. Ojal and Mwalimu Sacco by Mr. Mudhama and Mwalimu Sacco by Mr. Kinyajui has some legal problems. The Cooperative Tribunal in full house sat in the building generally called Uhuru in Mombasa. The Cooperative Tribunal is not exactly a kangaroo court. In full house, it has 7 persons. Of the 7 people, 4 are advocates. The chairperson and the vice chairperson are supposed to be advocates who are qualified to be judges of the High Court. The other 3 members are experienced people in the cooperative industry. In addition, the Cooperative Tribunal has a secretary. Now, the secretary of the Cooperative Tribunal is also an advocate qualified to be appointed a judge of the High Court. So, the Cooperative Tribunal is not a kangaroo court. Any decisions it makes that are in conflict with the law and any decisions that it fails to make in conflict with the law, it is not out of ignorance. When my 2 cases were called, my advocate was absent from the plenary of the tribunal. He had communicated to me that an arrangement he had made with a fellow advocate to defer a case in the High Court to a later date had gotten stuck. He had indicated that while he could not be before the tribunal in the morning, he could be turning up by noon. I did inform the tribunal of those circumstances. My advocate, the last of the gentlemen in the trade, had also sent his lady court clerk. The court clerk confirmed the same story, that my advocate would be turning up later in the day, specifically at 12, because he was unable to disengage from a prior listed case in the High Court. The Asenath Ogeri Tribunal declined to accommodate my advocate and myself, and they ruled that the case must continue because I was present. Imagine, I have paid an advocate to represent me, and the tribunal is ruling that the case has to continue in the absence of the advocate. Note also that the Cooperative Tribunal, those days, perhaps today too, they would dedicate one whole week to the Mombasa series of cases. The Mombasa series of cases are usually not very many. The case challenging my suspension was listed as 08 of 2011 at Mombasa, and it was the last case in the Mombasa series of cases in 2011. So let us say, like, when you are seated there before the tribunal, there could perhaps be a total of 10 cases for that week. 10 cases only for that week. So to fail to accommodate a person, you need to explain, is it because of a shortage of time? No, because the tribunal has one whole week. Or, which is more just, to defer the case to another season when the tribunal will be in Mombasa, or to insist on the case proceeding in the absence of the advocate. When the Asenath Ogeri Tribunal ruled that the case must proceed in the absence of my advocate, I knew that I was in for some rape, because it simply cannot fit in justice that a case proceeds in the absence of the advocate just because the claimant is present. So I could not help but feel like Daniel in the den of lions. I could not help but be apprehensive. I felt that I was standing before a contender for the title of the Queen of Punk. It would turn out that I was right. I was before an aspiring Queen of Punk, and I would be raped. I did not have a choice but to step forward and strongly attack. Like I said, the representation of Mr. Onjal and the Mwalimu Sacco in the contempt case by Mr. Mudhama, it would straight away raise grave legal issues. One, Mr. Mudhama needed to file a notice of change of advocates, which he did not. And he could not because he was not an advocate. There is no record of such a filing before the Asenath Ogeri Tribunal. Alternatively, Mr. Mudhama, an employee of Mwalimu Sacco, needed to file a notice to represent himself. And he could not, because it is Mwalimu Sacco that was the respondent, and Mwalimu Sacco was not Mr. Mudhama. But the advocate seated, knowing very well that that is the right position as per the civil procedure rules, they did not check Mr. Mudhama. It was left up to me to raise those issues, that there was no way that Mr. Ojal and Mwalimu Sacco could be defended by Mr. Mudhama. Mr. Mudhama stood up and said that he had represented Mwalimu many times and won. Now, this is what I keep calling incredible. That a person totally unqualified is testifying that he has represented Mwalimu Sacco before the tribunal and won. This is incredible. And it is shameful on the part of the Honorable Asenath Ogeri that a fellow conspirator can stand in the plenary of the tribunal and testify about how they have been romping in bed with Asenath Ogeri, because that is what it means, that Mr. Mudhama and the Asenath Ogeri tribunal, they do hold hands to rape the public. I then charged both Mr. Mudhama and Mr. Kenyajui, representing Mr. Ojal and Mwalimu Sacco, in two different cases based on the Civil Procedure Rules, Order 9, Rule 1 and 2. Now, the Civil Procedure Rules, Order 9, Rule 1 and 2, they are on what is called corporate representation. Who represents a corporate person before the tribunal? Note that the tribunal has conceded to the Civil Procedure Rules. So this is the right rule that is applicable here. Who represents a corporate person, such as a company, a cooperative, a school, a church, and the story goes on like that. Who represents those people? And the law is very clear. Under the Civil Procedure Rules, Order 9, Rule 1 and 2, a corporate person can only be represented by an advocate under the corporate seal of whoever they are representing. My other basis of challenge of the representation of Mr. Ojal and Mwalimu Sacco was under the Cooperative Societies Act. Under the Cooperative Societies Act, Section 12 and Section 28, subsection 1 and 2, it is only the governing committee of a cooperative that has the power to defend cases in court and prosecute, institute and prosecute cases in court. Now, if you are to read the Civil Procedure Rules, Order 9, Rule 1 and 2, and the Cooperative Societies Act, Section 12, and Section 28, subsection 1 and 2, the only way that Mwalimu can be represented in court is if the CEO of Mwalimu would turn up in court being introduced under the corporate seal by the governing committee, and that CEO is the one who is going to introduce the advocate who is going to prosecute or defend the case. That is how I outline the challenge. Imagine that you are the director of, say, Baburi Cement, and you learn of a case going on in court where Baburi Cement is the respondent, and you as a director, you are not aware of such a case. The case could be about the ownership of Baburi Cement, and you don't know. It's a grave mistake. For, as a matter of fact, we could say anybody representing a corporate person in the court without the authority of the board of directors is a crook, is sneaking to court, and could give away the company in court. That is why the law is so beautiful. It has covered the corporate person such that proceedings cannot happen in court against or for the corporate person without the authority of the owners of that company or that cooperative or that school or that church. It can never happen like that. Anybody turning up and attempting that is a crook, is a thug, and belongs in jail. After those technical objections to the representation of Mwalimu at that point, the tribunal decided to address itself to other cases without making a ruling on those technical objections. My advocate did turn up at 12 as he had promised. He apologized to the tribunal, he explained to the tribunal, and now the cases could proceed. In the case challenging my suspension and denial of the loan, Mr. Kenyajui challenged the filing of the case on the grounds of jurisdiction. My advocate responded, and surprise, the tribunal ruled in our favor that it had jurisdiction to listen to the case, and the tribunal did award us the costs. But you'll find that that is the last time that they mentioned costs. Ladies and gentlemen, citizens, coming up next in the court of public opinion is the video Rape by Gavin.